I'm disgusted and hurt that you did these things and are sitting there with these secrets.
What are you doing? What are you doing? I haven't done anything to her. You don't touch a 14-year-old girl.
She didn't ask to be lied to. She didn't want to die.
Here we have Christian Blaze Lobato, an 18-year-old girl who was accused of the murder of Duran Bailey, a homeless man in Las Vegas in 2001. She was tried twice for the crime and maintained her innocence both times. Bailey's body was discovered next to a dumpster in the parking lot of a bank building on July 8, 2001 at 10 p.m. under the mistaken belief that police were informing her that the man who tried to rape her had died. Lobato expressed remorse and made other comments that the detective mistook for a confession to Bailey's murder. Even though the event Lobato described contradicted the basic facts of his death, the investigators arrested her for Bailey's murder based solely on the statement. The police did not investigate obvious alternate suspects with the intent and means to kill Bailey so violently. Judge Miley approved Lobato's habeas corpus petition and dismissed her convictions based on overwhelming scientific evidence that could have been offered at her trial and would have likely affected the jury's decision.
I'm excited. I get a brand new start. I'm not asking anybody to just believe me. Look at the evidence, read the documents, see what is really there.
This is Clifford Williams, who served 43 years in prison for a murder he didn't commit before finally proving his innocence.
Just wanted to get out and be with my kids. They was gone and it wasn't nobody but...
Clifford Williams was 34 when he became a suspect in a murder and attempted murder case, along with his nephew. Despite the lack of solid evidence, they were found guilty. Williams was released from death row last year after lawyers unraveled the faulty case that had put him there in 1976. He spent 5 years on death row before his sentence was changed to life imprisonment. The turning point came when a new investigation revealed that the ballistics reports from the crime lab did not match the original testimony. This report was the only thing linking him to the crime. With this new evidence, Clifford Williams was finally set free, a moment he had been waiting for 43 years.
Mr. Williams and Mr. Myers, the indictments have been dismissed against you. You are free to go, and we are adjourned.
After being freed, he claimed compensation, but the state initially rejected his request. Later, Williams and his family sat in the gallery as the House cast the final votes necessary to award him $50,000 for every year he spent in prison for a crime he did not commit. In the end, Clifford Williams got the justice he deserved. This is 18-year-old Victor Nathaniel Rivas, who is on trial for the murder of Ethan Soto in Bexar County Court, Texas. On May 16, 2022, at approximately 3 p.m., Rivas allegedly shot Ethan Soto after luring him from his residence in the 2100 block of Alon Drive near Callahan Road on the northwest side of Oklahoma. The incident stemmed from a robbery that occurred on May 15th when Soto stole Rivas's THC cartridges. Soto's mother attempted to resolve the matter by paying Rivas for the stolen cartridges and meeting with him to give him the money. However, Rivas had revenge intentions in mind. A few hours later, Rivas sent a message to a young girl, requesting that she arrange a drug trade with Soto. The girl messaged Soto on Instagram, pretending to be interested in purchasing drugs from him, and arranged to meet him near his residence. On May 16th at 2:55 p.m., the girl informed Soto that she was in the vicinity, prompting him to leave his house to meet her. Unfortunately, the girl wasn't there, and Rivas unexpectedly attacked Soto. Several shots were fired at him, allegedly in retaliation for the drug robbery. Authorities arrested Rivas in August 2022 and charged him with murder. During his court appearance, Rivas made a disturbing gesture at Soto's family, who were also in the courtroom, resulting in an all-out brawl. At least 4 members of Soto's family attacked Rivas in the courtroom, throwing punches at him. 2 court bailiffs intervened to break up the fight, and the rest of Soto's family was escorted out of the courtroom. It was reported that Rivas sustained only minor injuries. After the incident, 2 adults and 2 minors were apprehended and charged with assault and disorderly conduct in an open court. This Karen had a whole monologue prepared for the court.
You can judge a world-renowned philosopher like myself? You're not in a place where you can judge the taste of a man's sweaty after he your mouth for $5, you revolting You don't get a you're not in a place in society where you get to have an opinion on the taste of the dirty that defiles your mouth. Slander about me is going to come out of the mouth that sucked a million for $5 each? Learn your place. I will rip your head off and take a down your throat and film it and send it to your parents on your birthday. Don't with me.
Emotional victim impact statements were read by the parents of Amanda Blue. They revealed that either Amanda Blue or Willie Craigist knew that Alicia Craigist was under the influence when they got into the car with him on August 26, 2023.
Drunk, and she did not drive at almost 2 times the legal speed limit. She didn't ask to be lied to. She didn't want to die. She wanted to change the world. And because of him, she doesn't get a second chance, so why should he?
Amanda's older sister asked the judge for the maximum sentence, saying that her sister's death had changed her forever.
I sit here and think about all the amazing times we had together and cry at the thought that there will be no new ones. He deserves the maximum time in jail because for taking their hopes and dreams away, for damaging my family beyond repair, and taking away everyone's opportunity to watch these girls change the world.
Blue's younger brother, who was 12 at the time of the incident, said that for months, he struggled to wake up on time for school because that was when he learned about his sister's death.
She was my world. We used to draw pictures together and do other things we both liked. I had the hardest struggle just to put words down on this paper because it hurts when I think of this.
Before sentencing Alicia Craigist to 30 years for his actions, the judge left him with a message.
There is no way to measure, nor words to describe, the suffering that you've caused your own family and the Blue family. I cannot quantify what happened. The sentence does not attempt to quantify what happened because it's unquantifiable.
Amanda's mother, Donna, shared that she is grieving for Amanda and Lily Ashwell, who was like another daughter to her. In a statement, the family said they do not view this as a victory, but as a small step toward highlighting the severity of drunk driving and the consequences of one's actions. Craigist was handcuffed and taken into the custody of the Michigan Department of Corrections. Before leaving, he stated that he would never drink again and left a message for both families.
I know there is nothing I can say to fix anything. I'm ready to face the consequences for that night and I hope that can provide some level of justice.
The judge also ordered him to pay a little over $24,000 to Amanda Blue's father. This is Gregory Agnew. In a chilling tale of love turned deadly, the case of Gregory Agnew has captivated Michigan residents for decades. Born on November 1st, 1967, Agnew's life took a dark turn when he became romantically involved with Tammy Niver, a woman who would later vanish without a trace in August 1993. Friends and family knew their relationship was far from idyllic, with reports of possessiveness, toxicity, and cruelty on Agnew's part, even after the birth of their child. When Tammy went missing just days after their breakup, suspicion fell heavily on Agnew. However, despite exhaustive efforts, detectives struggled to find concrete evidence linking him to her disappearance. Enter Tammy's friend, Martha McGeorge, who bravely offered to cooperate with law enforcement by wearing a wire to provoke Agnew's confession. Shockingly, the plan backfired when Agnew and McGeorge started dating, leaving investigators stunned.
You walked out of that bedroom?
I don't think I went down there.
You don't think you went down to the bedroom?
I don't think so.
You never looked in that bedroom?
I don't know.
You never looked at Martha laying in the bed dead?
I don't know.
I thought you had a good memory of February 17, 2018.
I don't recall.
Believing Agnew was still the prime suspect, authorities pursued every avenue to get him to confess, even attempting to subpoena Martha in 2014. However, their efforts were thwarted when she married Agnew that very month, rendering her legally unable to testify against him. Fast forward to January 2018, with Gregory and Martha now amid divorce proceedings, detectives once again sought Martha's cooperation. Regrettably, she refused to assist, seemingly distancing herself from the case. Tragically, just days later, Martha was found murdered in the township house she shared with Agnew. An autopsy revealed that she had been strangled, and drugs were found in her system. While Agnew remains the primary suspect in both the disappearance of Tammy Niver and the murder of Martha McGeorge, he has only been indicted and convicted in the latter case. Throughout his trial, Agnew and his defense team attempted to present a different image of Martha, implying she led a high-risk lifestyle and was involved in an extramarital affair. Their theory suggested that she was killed by an unknown male attacker while under the influence of drugs.
Understand how anyone can take a mother away from their kids? Not once, but possibly twice. I'm disgusted and hurt that you did these things and are sitting there with these secrets. Where is Tammy, Dad?
However, the 12-member jury remained unconvinced by Agnew's defense, ultimately finding him guilty of murdering his wife and sentencing him to life in prison. At 53, he resides in the Bellamy Creek Correctional Facility, where he'll likely spend the rest of his days. As this haunting case continues to baffle authorities and the community, Gregory Agnew's connection to the disappearance of Tammy Niver remains an open question. Though he has never been prosecuted for her vanishing, the Washtenaw County Sheriff's Office persists in their investigation, determined to bring closure to this unsettling mystery one day. Next, we head to the McLennan County Courthouse in Texas, where Sean Forster faces charges of burglary, intent to commit, and child indecency. The circumstances that led him to court were shocking and deeply disturbing.
He would take pictures of me.
Naked?
No. He'd be like, oh, turn around, and he would take pictures of my butt.
Brandon Moore and his wife Leon were desperate after reporting that their daughter Maddie was being mistreated by their friend Sean Forster. The waiting game with the police was unbearable, so Brandon hatched a plan to catch Forster. Brandon and Leon were consumed with dark thoughts when they realized what was happening. Leon imagined confronting Forster, while Brandon considered drastic measures, but knew the consequences would devastate his family. Instead, the former Marine with a PhD decided to set a trap. Maddie, who worked part-time for Forster's pool construction business, regularly texted him. Brandon sent a message from Maddie's phone, pretending to be her, saying she would be ready to work after a shower. With the trap set, Brandon locked the front door, turned on the shower, and waited while Leon watched from a distance. As soon as Forster entered the house, Leon called 911. Brandon recorded the confrontation on his phone. Forster ripped open the shower curtain, only to find Brandon waiting for him.
Hey, what are you doing? What are you doing? I haven't done anything to her. You don't touch a 14-year-old girl!
Filled with rage, Brandon attacked Forster, beating and choking him. The police arrived and arrested Forster, who was charged with multiple counts, including burglary and indecency with a child. His bail was set at $500,000. Despite the serious charges, Forster made bail and rejected a plea deal that would have given him 20 years in prison, opting for a jury trial instead. Brandon's thoughts of revenge resurfaced as the legal process dragged on. During the trial, the prosecution presented the audio recording of the confrontation, which played a crucial role in illustrating Forster's intent.
What are you doing? What are you doing? I haven't done anything to her. You don't touch a 14-year-old girl!
Maddie also testified against Forster, confronting him in court and reaffirming his guilt. The jury found Forster guilty on multiple counts, and he was sentenced to 55 years in prison, a sentence that brought some measure of justice to Maddie and her family. Brandon did not face any charges for the beating, a fact that brought relief and a sense of vindication to the Moore family. Maddie expressed satisfaction with the outcome, though she wished for an even harsher penalty for such crimes. This woman goes wild after hearing her sentence.
All right, so, based on that...
Well, can I say something, Your Honor?
Sure, Ms. Williams, say.
Epileptic. And there were 2 appointments. I missed the first one because they were not for She said that the appointment was for 11 o'clock. That day I had to do, and then on the 18th, on the Friday, I was there. She said, I don't have the reception in my office.
She didn't get a discount.
Okay, because I didn't see anything
Yeah,
like
she didn't.
that.
It was merged with the other ones. So you had an appointment.
So I had it. The appointment's for 12 o'clock, and then she said it was scheduled for
11.
So what I did was I went down there on the 18th to meet with her to see whether or not she was treated. I needed to see a psychologist because I had already thought the psychologist, Dr. Susan, who had declared me competent. So they needed to get different opinions. Dr. Joseph White said that I was bipolar. Dr. Susan said that I was competent to stand trial. And Dr. Valley doesn't like me.
Okay. She's remanded into custody. Get somebody else to do other than Bradley to do the evaluation. As soon as she's, because we have Sussman.
Let me go. I got kids and responsibility. Y'all, let me go. No, let me go. Me go.
Here's the courtroom.
You're trying to accuse me of something I didn't do. That should be enough to satisfy the court's argument. Finally strike the judges. Get my purse. Respect her own goddamn. Sorry. I complied. Did you comply? Were you a woman of your word? Did I not see 3 psychologists? Yes or no? Swear before God.
Christina's gone. I would think that if I was everybody, I would just kind of. We've had enough.
Next, we have Karen, who was brought in as a witness and refused to take the oath.
You'd stand right there at the rail for me, please, sir. Raise your right hand for me. You solemnly swear or affirm testimony given this cause to be the truth, whole truth, and nothing but the truth, so help you God.
I don't know what this is about.
Hey, Judge, may we approach?
I don't understand what's going on.
I'm swearing you in as a witness. So,
Under what authority, sir?
all right, jury, go to the jury room. Everyone may be seated. Mr. Mata? Is your name Manuel Mata?
Yes, sir.
Your date of birth is 7/8 of 1980?
Yes, sir.
All right. I have issued you an oath to testify truthfully. Are you going to take that oath?
I have a question, sir.
No. Are you going to take that oath?
No.
All right. You are on bond on some cases, is that correct?
Yes, sir.
Those bonds are being declared insufficient, Sheriff.
For what, sir? What's going on? What did I do? I need my lawyer present, sir.
We will get your lawyer.
You questioned me without a lawyer present. And I don't know what y'all doing. I don't know what's going on. For what? For what? I asked him a question. I don't have no knowledge of this case. And I just wanted to know who's asking for me to be sworn in. The DA, the defense, the judge, who's asking it? Those are questions I need answers if you're going to revoke me. You ain't got to be aggressive when you do.
Let me see the lawyers.
Yeah, we can't.
In July 2019, in Milwaukee, Brooklyn Harris was tragically shot by the monstrous Antonio Bratcher. Even 1,000 lifetimes wouldn't suffice as punishment for his crime, but let's see what the court decides. Prosecutors often read victim impact statements, conveying the intense pain of those unable to attend the court after losing a loved one.
Thank you. Then, State, you may proceed.
Thank you, Judge. Your Honor, I'll start with Ms. Miller's victim impact statement that she asked me to read for her. I know she's struggling to be here in court today, so it was her intention to address the court herself, but she asked me now. I don't know who or what raised you, but I'm sorry it wasn't with love. My daughter would have been 6 years old this July. You took that from me. You took that from us. Brooklyn's siblings still ask for her. They still think she's at the doctor, so when they see their doctor, they ask for her.
They don't understand that she's gone. Brooklyn's sister is depressed because the other kids at school talk about their sister, but she doesn't have a sister to talk about. All she knows is that a bad guy took her, but thinks she's still in the hospital. There's nothing I can say that will bring her back or take the pain away. I don't hate you. I hate the fact that you aren't man enough to admit your wrongdoings. It shows the coward that you really are. And that's the end of her statement, Judge.
You may proceed.
Thank you. Your Honor, as you'll recall, this was a case that went to trial in front of Your Honor starting at the end of November and went about 6 days. There was a lot of evidence put on by the state, a lot of testimony that I will highlight for the court. This case, the incident that took the life of Brooklyn, happened on July 13th of 2019. As you'll recall from the testimony and evidence, that morning around 8:30, Arnetha Miller and Shaquisha Nunn were in the car with 4 children, 4 very young children, including 3-year-old Brooklyn Harris. That morning, they were around 42nd Street and Bonnie Place, and as the women testified at trial, there was some kind of interaction between their car and the defendant's car that seemed rather minor to the women, but apparently it wasn't to the defendant. As they pulled into traffic ahead of his car, they all of a sudden noticed that he was following them, and after a very short period of time, shots were fired from the driver's side of the defendant's dark-colored SUV, a car that was discussed a lot at trial and that was distinctive because it had that pink decal, I guess, on the front, and there was also some decals on the back, which became important later, as the court, I'm sure, recalls, in identifying the vehicle by both witnesses and the police. I think Shaquisha Nunn, during her testimony, really colored for everyone in the courtroom what that experience was like. You could see how emotional she was recalling these incidents, and just the pure panic and terror that these women and these children were experiencing on that day. About an hour and 20 minutes after the shooting took place, officers from Milwaukee Police Department came into contact with Mr. Bratcher's vehicle and Mr. Bratcher. There was a chase that lasted approximately 1 mile that ended in a car crash. Neighbors in the area saw Mr. Bratcher run from the vehicle, and officers ended up chasing him throughout the neighborhood, finally finding him hiding under a porch not far from where the crash happened. Officers that testified at trial identified him. Officer Anderer testified that she saw him when he first got out of the vehicle and ran, and then saw him later after he was found under the porch. And then Officer McGrath testified in trial as the person who identified him under the porch. As the court may recall, there was clothing left in the flight path by the defendant after he left that vehicle and before he went underneath the porch in that neighborhood. And that clothing was identified back to him as there was DNA on it found by the crime lab. The vehicle that Mr. Bratcher was driving was searched by police. There was a firearm located in that vehicle, and the casings that were found on scene were from the same firearm that was found in that vehicle. That is what the crime lab expert testified to at trial. We know from ring video that the defendant left in the vehicle that morning around 7:30. We could even see on the ring video that there was a firearm in his pants, and there was also a jail call where the defendant talked about having a firearm on him that morning. We also saw in that ring video a hat that was found in the back of the vehicle after the crash, as well as a shirt that was consistent with what he was wearing that day. Obviously, Your Honor, the jury convicted Mr. Bratcher on every count in this case. They believed the testimony of the witnesses and found that the state had proven their case. I think the thing about this case, Your Honor, that's so hard to understand is this just seemed like a regular day to these women. This wasn't a situation where these women were part of a drug deal. They didn't engage with Mr. Bratcher in any way. They didn't know Mr. Bratcher. There just seems to be absolutely no explanation for this behavior. And the danger of arm into a vehicle with 6 people in it, including 4 small children, is the exact kind of conduct that's happening in Milwaukee right now, and the reason that our homicide numbers for the month of January were through the roof, over 3 times what they've been in the past. And Mr. Bratcher is not a young man. He was 39 years old at the time of this offense, which relative to the population is still a young man, but relative to the types of individuals that we see committing these crimes, I think he's well past the age of knowing better. He's well past the age of someone who should be acting this recklessly and putting the lives of our community in danger. Mr. Bratcher did not testify at trial, Judge. He did give some statements to police that were not part of the evidence at trial. He never gave any admissions to the shooting. He did say that he was driving the car that morning. He said that he was driving some friends around or something of that nature. And I believe he did talk about being in the car during the fleeing. So there was some admission to the fleeing behavior, but to my recollection, there was no admission regarding any of the shooting. There was additional evidence that the state had hoped to put on at trial, but witnesses were just not able to be found. Mercedes Ferguson, Mercedes is MERCEDES, Ferguson, FERGUSON, was an individual who did identify Mr. Bratcher in a lineup. She was a neighbor who saw him after the fleeing incident and then saw him crash the vehicle and get out, and she did affirmatively identify him in a lineup. The other witness who I think was sort of obviously missing from the trial was Kaylee Jo Turnbull. Kaylee is Kayle, Joe, J-O, Turnbull, Turnbill. She was dating Mr. Bratcher at the time of this offense, and it was actually her vehicle that was involved in this incident. It was her SUV with the decals and the writing on it. And I think one of the things that she definitely would have helped establish at trial is that he would have been the only person driving that car. She was also the person who turned the ring video over to police and identified him in the video.
Even in the face of the unforgivable, the court grants the criminal one last chance to speak, as required by law. However, if they remain silent at that moment, it makes it easier for the court to pass judgment.
Thank you. Mr. Bratcher, this is your opportunity to talk to the court. Is there anything you wish to tell me before I pronounce sentence? Or, as the statute said, is there any reason sentence should not be pronounced today? No, sir? All right, thank you. So, at sentencing, how does a judge approach a difficult case such as this? The court, first of all, identifies sentencing objectives. These objectives in this case are very straightforward. They are punishment of the defendant, protection of the community, and deterrence of others. To the extent there's rehabilitation, that will be found in the Wisconsin State Prison System. The court must address the three primary sentencing factors: gravity of the offense, need to protect the public, and character of the defendant. The gravity of the offense analysis requires the court to look at the facts and circumstances of each count and to determine whether those facts and circumstances are worse than other cases, such as this, that would be aggravated, whether they're typical, that would be intermediate, or whether they're less serious, that would be mitigated. So the court will use aggravated, intermediate, or mitigated to discuss how serious the facts and circumstances are in each of these charges. Now, the court will briefly review the potential penalties because this becomes important when the court fashions the sentence. And the defendant was convicted in count 1 of first-degree reckless homicide, use of a dangerous weapon. So he faces potential 60 years in Wisconsin State Prison, broken down into 40 years potential initial confinement and 20 years potential extended supervision. But because it's use of a dangerous weapon, that 40 years is enhanced to 45. So for count 1, he's looking at 45 and 20. For counts 2 through 6, which are the first-degree recklessly endangering safety, use of a dangerous weapon, that starts out as a Class F felony up to 12 years and 6 months in the Wisconsin State Prison, broken down into 2 potential maximums, 7 years and 6 months potential initial confinement and 5 years extended supervision. But the use of a dangerous weapon adds the 5 years to the potential initial confinement. So his potential initial confinement on counts 2 through 6 are 12 years and 6 months potential initial confinement and 5 years extended supervision. And then on count 7, possession of a firearm by a felon, he faces up to 10 years Wisconsin State Prison, 5 years potential initial confinement, and 5 years extended supervision. And on count 8, he faces up to 3 years and 6 months in Wisconsin State Prison, broken down into 1 year and 6 months potential initial confinement and 2 years potential extended supervision. State, you agree with the court's explanation of years?
Yes, Judge.
Defense?
Yes.
So the defense is correct that the court has ample range to sentence the defendant to a proper and just sentence. The focus on the case is the first-degree reckless homicide, use of a dangerous weapon. That has the greatest penalty. But this court is going to start with the possession of a firearm by a felon. And if you think about the facts and circumstances in this case, when approximately 7:30 in the morning, the defendant leaves the house, according to the Ring video, and the .45 caliber firearm is on his person, he's not only guilty of that offense at that moment and at later moments, of course, but he's already committed the Class G felony in count 7, and the circumstances are outrageous. Defense, is there credit for time served?
941 days.
Court awards 941 days. Credit against count 1, the greater sentence. And the court knows that he's not eligible for the substance program on count 1, but he's not eligible for the Wisconsin substance program on any count because the court finds that that eligibility would reduce by too great an amount the amount of punishment that I've determined is appropriate for his sentence. I think at 42 he's not eligible for the challenge incarceration program. So he's ordered to provide a DNA sample. He's ordered to pay the court costs, fees, and surcharges connected with this action. He has 58 years to pay, and failure to pay will result in a civil judgment. The court orders the Department of Corrections may take a percentage deemed reasonable from his prison funds. Again, failure to pay will result in a civil judgment. Restitution has been previously ordered. It gets priority over the court costs, so the restitution is to be paid to the Crime Victim Compensation Fund. I'm changing the time frame for that. He has 10 years to pay that, and failure to pay will result in a civil judgment, and restitutions to be paid first. Conditions of extended supervision, no violations of state or federal law that rise to the level of probable cause, absolute sobriety to be monitored by random drug tests and breath tests, alcohol and other drug assessment, mental health assessment, follow recommended treatment, including therapy, counseling, and taking prescribed medicine. He's to successfully complete a cognitive thinking behavioral modification program. He's to have no contact with the victims listed in counts 2 through 6 or their families. I'll have to work with the clerk to make that list. State, is it okay for me to name those names?
That's fine, Judge.
Count 2 was Ariel Campbell. Count 3 was Jeremiah Campbell. Count 4 was Chantel Harris. Count 5 is Arnitha Miller. Count 6 is Shaquisa Nunn. So no contact. Because you're a convicted felon again today, you may never possess a firearm at any time in the future. If you do so and are convicted, you'll face Class G felony penalties, up to 10 years in prison, $25,000 fine, or both. You can't vote in any election until your civil rights are restored. You can't use, possess, or have body armor of any kind, subject to felony penalties. You have a no contact order. If you violate the no contact order, you're subject to Class H felony penalties. Again, the court has made counts 1, 7, and 8 all consecutive to each other, and the overall concurrency of 2 through 6. So they're consecutive to those others as well. Sentence is forthwith. I'm giving the defendant a written explanation of the determinate sentence. You have the right to appeal. Any notice of intent to pursue post-conviction relief must be filed with the clerk of circuit court within 20 days of sentencing. Your lawyer must continue to represent you until the decision to seek post-conviction relief or not is made. And if you wish to seek post-conviction relief, your lawyer must file the necessary notice within the 20-day period. Anything else, State?
No, thank you, Judge.
Defense?
No, Judge.
Thank you for your patience. We're adjourned.
On December 31st, 2021, in Cleveland, Officer Shane Bartek fought valiantly against injustice, but fell to the ruthless Tamara McLeod. The pride of giving one's life to the country is immense, but when life is lost defending the law against a brutal criminal, agony overshadows all pride, leaving only sorrow and a sigh.
Shane was the epitome of life and light. He loved to give, to help, to save anyone and everyone he could, because that's who he was. Things weren't always easy for us. We were both born addicted to drugs by our birth mother and abandoned by our birth father and put in the foster care system. The odds were stacked against us, but we didn't want to be where we came from, so we fought every day to be the best we could be.
I'll give you a minute, ma'am. When you are ready to speak, we do need to know who is present and speaking, so make sure you let us know your full name, and we'll be happy to hear what you have to say.
My name is Janine Height. I am the mother of Jada Height.
Miss Height, you don't have all the time you need.
You okay? No.
Let me read it for you. Your Honor, with my client, we have spoken.
I'll read it.
All right. Come on, take a deep breath.
I'll wait for you.
I have been employed for over 15 years as an administrator. Please accept my character witness reference on behalf of my daughter. Before I start, I want to send a sincere apologies to the victims and healing energy for any trauma this has caused. I know she wasn't involved, but you're a victim. Jada is my youngest child of 4 children, and she is a twin. She was always so loving and enjoyed being around her family and friends. I could often depend on her to help care for her nephews. My daughter indeed strayed off the path that I hoped for her, but I remain convinced that she possesses the desire to learn from this experience. She has graduated out of high school and wants to continue a path of growth. She has a large, committed support system in me, as well as our extended family. While incarcerated, we will be there for her, and when she is released, help her to stay on a positive path. In closing, I am respectfully requesting the court to grant leniency and render a decision that will assist with her rehabilitation. Thank you for allowing me to read this letter.
First of all, ma'am, thank you for being here. Thank you for making this statement. Second, I do want to ask you if there was anything else, information that you wanted you to mention here that you haven't mentioned already.
No, Your Honor, I think this young lady has spoken from the heart, and I think she's made her point. Thank you.
And Ms. Bueller, do you have anything in the nature of the process?
No, Your Honor.
And Ms. Height, you are experiencing the nightmare that any parent might have. Doesn't matter how much you love them, no matter how much you try to provide for them, guide them, direct them. We can only hope not only that we're doing it right, but they're receiving it the right way. And a lot is out of a parent's control, and you are learning that in a way that frankly I wish you wouldn't. Not only for you, but obviously for the people that you victimized over time. So you have my sympathies, you have my gratitude for being here today to speak for your daughter, and I wish you the best. So thank you, Mr.
Thank you. Your Honor, there are other people are here for support, and I think would frankly be sort of cumulative. So with that, I know that my client is appropriately nervous, but would like to address the court.
All right, so we are back on the record. Thank you for giving me those moments, ladies and gentlemen. I appreciate it. Ms. McLeod, if you would kindly stand, please, I will be grateful. On count 1, the aggravated robbery on December 25, 2021 of Rafael Hernandez, the jury finds that you are guilty. Therefore, the specifications are pertinent. The jury finds on the specs not guilty. Count 2, the aggravated murder on December 31, 2021 of Shane Bartek. The jury finds that you are not guilty. The specs are therefore appropriately left blank. On the lesser included count of murder, count 2 as charged, the jury finds that you are guilty. The specs are therefore pertinent, and the jury finds that not only did you have and use a gun, that you also discharged it at a peace officer. So guilty on all 3 specs. Count 3 aggravated murder on December 31, 2021 of Shane Bartek. The jury finds that you are guilty and finds guilty on all specs. Count 4, on December 31, 2021 of Shane Bartek. The jury finds that you are guilty and guilty on all specs. Count 5, the aggravated robbery on that same date of Shane Bartek. The jury finds you guilty and finds you guilty of each specification. On count 6, B, as we sometimes refer to it as, the jury finds that you are guilty and finds guilty on all specs. Count 7, the felonious on December 31 last year of Shane Bartek. The jury finds that you are guilty and guilty of all specs, and that furthermore the jury does find that the victim of the offense was a peace officer. Count 8, the other count of felonious, the jury finds that you are guilty on the charge itself, guilty on all specs, and that furthermore the victim of the offense was a peace officer. Count 9, theft of a motor vehicle, the jury finds that you are guilty. The jury further found that the property was beyond a reasonable doubt a motor vehicle, and furthermore guilty on the specs. Count 10, theft, the jury finds that you are guilty of that charge as well. And ladies and gentlemen of the jury, while you have been deliberating these 10 counts, I, as the trier of fact, have been deliberating 2 additional counts, namely a count of having a weapon under disability for each date, December 25 and December 31st. It is a crime in Ohio to possess a firearm under certain conditions, including a condition where you have a juvenile adjudication for a serious crime. Those counts have been tried to the court. Having considered every bit of evidence pertinent to those counts, Ms. McLeod, I do find you guilty of both counts of weapon under disability from December 25 and from December 31st. The next step, or, well, actually, let me slow down for a second. I will affirm that all forms were appropriately signed by all the jurors. In other words, all 12 have signed where verdicts were reached. There was one form that probably didn't have to be filled out. It's worth, I guess, mentioning. One of the well, suffice to say, there was a finding of, well, I thought there was a, on count 1, the aggravated robbery, the jury found guilty, as you know, and I've just announced. Therefore, the specs came into play, so to speak. On the first spec, having a weapon, the jury found that Ms. McLeod did not have a firearm. The jury went on to fill out the second spec, having and using. It's a tiny thing, but you didn't necessarily have to fill that one out because you had already filled out, did not for the first. But actually, you were thorough, so I appreciate that. So there's an argument that that second form was extraneously filled out, but suffice to say, everything is correct as far as I'm concerned. And I know you were composed and civil then, in contrast to somebody else in this courtroom. So I do appreciate you. So, in case number 669261, Ms. McLeod, on count 1, you are ordered to serve 6 years on the felony aggravated robbery and 3 years on the firearm specification. On count 2, you're ordered to serve 7 years on the felony, 3 on the spec. Count 3 is allied, no sentence is imposed. On count 5, you are ordered to serve 8 years at the Ohio Reformatory for Women. If I said LCI at some point, then I misspoke. It's ORW, the women's prison. Count 5, 8 years on the felony, 3 on the spec. 6 is allied, no separate sentences imposed. 8 is allied to, actually, I don't think 8 applies here. One moment, please. Actually, 8 does apply. On count 8, I find that that is an allied offense of similar import to all the others. And no sentences imposed on count 8. On count 9, Cleveland Heights, you're ordered to serve 8 years on the felony and 3 on the spec. And on count 11, the weapon under disability, you're ordered to serve 12 months. In case number 669473, the Christmas with Rafael Hernandez, you're ordered to serve 8 years on the felony. There was no firearm spec there. On count 2, the weapon under disability, you're ordered to serve 12 months in prison. In 666570, on count 4, the aggravated robbery, you're ordered to serve 8 years in prison plus 3 on the spec. On count 10, you're ordered to serve 12 months in prison. Excuse me. Sorry, ladies and gentlemen. It's not COVID. I just have something in my throat. I'm going to hold off for 1 second. You okay, Kelly? On count 2, Ms. McCoy, the aggravated murder on December 31, 2021 of Shane Bartek, you are ordered to serve a sentence of life imprisonment with first parole eligibility, if at all, after 25 years. That is on the felony itself. You're ordered to serve 7 years on the firearm specification, which is going to be consecutive to the 3-year spec on count 4, and of course, the life sentence. Here, all counts in 669261 are ordered to be served concurrently with each other, and the 4 specs there concurrently over the state of Ohio's objection for essentially 11 years in that case. And count 11 is concurrent as well. In Rafael Hernandez's case, the one ending in 473, you're ordered to serve the 2 counts concurrently. There was no spec there for a total of 8 years in that case. And in 666570, you're ordered to serve counts 4 and 10 concurrently, but consecutively to the 2 specs and prior and consecutive to the life sentence. What this means then is on the felonies themselves, and then the felonies in the first case, the multiple aggravated robberies, those are all concurrent with each other, but they're ordered to be served consecutively to Mr. Hernandez's case and Mr. Bartek's. In Mr. Hernandez's case, that sentence is ordered to be served consecutively to the aggravated robberies and Mr. Bartek's. And then in Mr. Bartek's case, 570, all of that is ordered to be served consecutively to the other cases. So those are the sentences. Now, on the felonies, on the felonies of the first degree, the aggravated robberies, those are qualifying offenses of the first degree pursuant to the provisions of Revised Code 2929.144, effective March of 19. Therefore, it is rebuttably presumed that you will be released from service of those sentences on the expiration of the minimum term imposed by this court, namely the 8 years on those each count.
Another individual, behaving like a Karen who undermines the judge's decision, ends up with a harsher sentence.
Good morning, Ms. Burks. You're charged with assault. That's a misdemeanor 1, carries a possible fine of $1,000 and or 6 months in jail, and carries a possible fine of $1,000 and or 6 months in jail. Guilty, not guilty, no contest. You also have the right to a lawyer, and if you can't afford a lawyer, the court can appoint one for you. What plea would you enter?
Not guilty.
Court will accept your plea of not guilty. I'm going to assign your case to one of the courtrooms. All right, Ms. Burks. On the domestic violence, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact. On the assault, I'm going to set a $7,500 cash or surety bond. That bond is conditioned of no contact with Tiffany Castro. No contact means you can't call him. You can't go visit him. If you go someplace and either Mr. McRae or Ms. Castro's there, you have to leave. If you're someplace, even though you may have arrived first and one of them shows up, you still have to leave.
So you gonna tell me I can't go home?
I'm telling you, you can't go home. If you live with Mr. McRae, you cannot return to that residence.
Oh, but how you just gonna tell me I can't go home?
I just did.
Well, I bet I do.
Well, then you're in contempt, young lady, and you've got 30 days. So you're not going. You're not what?
Whoa.
Get back! Get back!
Get back!
That's another 30 days. That's 60 days.
So what? So?
120 days.
Okay, and?
180 days.
Oh! He's quiet. Get off me. Get your hands off me, man.
We'll talk in 6 months when you're ready to come back for your case.
I ain't bad. They got commissary. I got money.
That's 200 days. You got anything else to say, Miss Burks? That's 300 days.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.